Any mention? Item number 1.
Yes.
It is for filing of rejoinder.
Yes, Joanne is ready?
Lordship, I'm appearing on behalf of
Yes. Yes.
Lordship, I'm appearing on behalf of Dr. P. Agarwal for
Very good.
respondent.
Yes,
Sole
very
respondent.
good. Very good. Yes, where is your rejoinder?
Lordship will be filing it during the course of today. It's just going up for signature.
Yes, then Attorney General that the rejoinder affidavit will be filed in the course of the day. But this is the matter after 2 weeks for hearing. Yes.
Yes, my lord.
Record. What's her name? MS ZR Majumdar for the respondent vice Dr. P. Agarwal. Yes.
Hearing. Item number 2.
Lordships. Lordships.
Yes. Yes.
Lordship,
Yes.
as per the instruction, Sir KP was supposed to file for adjournment, my lord.
Miss who? Who's the file?
KP, sir.
Who's KP?
For the private respondent. She's appearing on behalf of KP.
Yes, my lord. I'm appearing on behalf of Mr. K.P. Bhattacharjee. My lords, kindly adjourn the matter. He has some personal difficulty.
He's for the private respondent.
Private
The
respondent.
beneficiary.
Lordship.
Yeah, for the appellant.
Appellant.
Then you're not ready with the matter. Yeah, are you in the matter?
Lordship,
For the respondent number, what's the
Lordship,
private respondent? Respondent number?
Lordship 9. Sonia Sultana Sharkar. Respondent number 9, my lord.
She's serving right now. She's
Lordship.
in office. When was the appointment done? Yes, MS Sham. When was she appointed?
Lordships, I do not have the file with me.
In fact, Your Lordship, the appointment of the writ appellant has been set aside by the learned single judge, Your Lordship.
The appellant.
Lordship. Then you file.
And this number 9 appointed in her place.
No, Your Lordship, then advertisement has been called, Your Lordship.
Or then no one's in contention. Then when do you want it?
After.
Yes, on the prayer been made on behalf of the respondent number 9 for adjournment due to the unavailability of the arguing counsel. Stop when?
2 weeks, lord.
Lordship, 2 weeks.
2 weeks, yes. Otherwise,
Faithful.
I know.
Any mention?
Lordship, I beg to mention item 22, Lordship.
Why?
The leading counsel is having some personal difficulty, Lordship, as well.
Holding counsel, Mr. Walang.
Yes, Your Lordship.
Yes.
No objection.
What's the matter about?
It's about this compensation. They want a job in lieu of the land they have given to the government.
So give them a job.
Without
Yes.
without our concern, Your Lordship.
No.
If late,
Get ready with the
Yes.
matter, we'll take it up.
no, Your Lordship, I have no instructions.
Okay. Yes.
2 weeks time, Lordship, granted.
Hello, Bletcher.
Highly obliged, Lordship.
Yes.
Lordship, I beg to mention item number 24, Lordship.
No objection, Your Lordship.
Yes.
Your Lordship, I beg to mention item number 19.
Hardly no hearing matters today. Yes.
Lordship, 90.
Your objection?
This is a petition. I'm for a petitioner. Actually, this is pension matter, my regularization.
No, we'll take it up. Yes.
She's having some personal difficulties, Your Lordship, as Anne. Ms. Asan.
Was it heard?
It was because only just one annexure was missing. Then I have corrected and put it as part of order, Lordship.
We don't want to keep these matters pending. Okay, after 1 week.
Lordship.
1 week enough?
Yes, Your Lordship.
Yes.
Much less, Lordship.
Number 20 has been some time. Number 20.
20? Yes, who's for the respondents?
Run for the state.
Yes. Yes, Mr. Monsuri.
Anyway, next week, anytime.
Yes.
Next week. Anytime.
Okay, after 1 week. Yes.
All right.
Please, Lordship. Should I beg to make a mention on item 25?
On behalf of Jeshila?
Yes, Lordship.
Your objection?
No objection, Your Lordship.
This is supposed to be compromise, correct? Only for
No,
the
Lordship.
resolution, not this matter.
No, not
No, Your Lordship.
Yes.
This matter pertains to
Boundary dispute.
It was sent to mediation, but it was not settled. Come for
Okay, after 2 weeks. Yes.
Lordship.
May I please, Lordship? Lordship, I beg to mention one unlisted matter, Lordship.
For tomorrow?
Yes, Lordship.
What is it about?
Lordship, we have filed one writ petition before this Honorable Court for compensation, Lordship, in regards to National Highway number 62 and 217. Now, thereafter, Lordship, the state had submitted their affidavit and stated that the land of the petitioners was never acquired by the state government, neither for National Highway 62 and 217. However, Lordship, a letter was issued to the petitioners by 15/6/2026, Lordship. Lordship, through this letter, Lordship, it was directed to the BDO to to conduct eviction drive on 23/6/2026.
Yes. We comply with which order of the High Court?
Lordship.
Is it 24/26?
Yes, Lordship.
Which order is that? 2004? Order of this court?
Yes, Lordship.
Your P. Ghosh?
Yes, Lordship. Lordship, in paragraph number 2, Lordship, wherein it has been clarified that there is no acquisition presently being undertaken either under NH62 or in 217 in respect of the land in question.
Yes, so you're encroachers into the ROW.
No, Lordship.
Then?
Lordship, our land...
There was no acquisition, then how you're there?
Land was never acquired, Lordship. We are the absolute owner of the land, Lordship. Land was never acquired by the government. Neither
The only finding of this court was that this land which you are talking about, it falls within the ROW right of way. Correct?
Lordship,
so there's no question of acquisition. So
yes.
if you're occupying the the part of the road which is part of the ROW, then you have to be evicted.
Lordship, they have already submitted before the court is, Lordship, the land was never acquired, Lordship.
Okay, let it come.
Neither compensation was.
Take it back. Yes. Yes. Follow.
May I please, Your Lordship? Lordship, I beg to mention item 27. Lordship, 2 weeks time maybe.
No objection, Your Lordship.
No objection, my lord.
Follow. Yes.
Obligation.
Some more.
Please, Your Lordship. Your Lordship, I beg to mention item number 23. It's a joint request, Your Lordship.
Request, Your Lordship.
Then this is the point of having weekly justice. After 3 weeks or 4 weeks.
3 weeks, Your Lordship.
Yes.
Obliged.
I beg to mention item 21, Your Lordship.
Some matters will remain for mentioning. Why?
21.
Senior counsel is not available, Your Lordship, today.
Oh, you're there. What's the matter about?
There's a land acquisition, Your Lordship.
Ready?
So fix after 2 weeks, Your Lordship.
Yes, Mr. D. Yes.
My lord, in this matter, district council has a very limited role. It is for the petitioner and the state, my lord, because it's of land acquisition matter, my lord.
Okay, after 1 week is.
Supplementary list item number 1.
Please, Your Lordship. Lordship, in this matter, the petitioner, my lord, had originally filed a writ petition which my lord had himself adjudicated. The disposal order of my lord simply directed MEPDCL to consider my case for regularization within a period of 4 weeks and pass a reasoned order. Instead of passing any order, they preferred a writ appeal before the division bench.
Yes.
Division bench, my lord, rightly observed that there was nothing to appeal against. And at page 19, if Lordship kindly sees,
yes,
para 7, direction given by the learned single judge to consider the petitioner's case to be decided by the appellant authority within 6 weeks from today. That was the only limited direction. This was on 11th February, my lord. 6 weeks expired sometime at the end of March. Thereafter, my lord, we issued a reminder also, page 20.
Yes, who's appearing? Are you accepting notice, Mr. Pandey?
Yes, my lord, I'll accept notice.
Why?
I'll come back to. I'll come
Yes,
back
sir,
to.
Mr. S. General and Counsel Petitioner, issue notice. Mr. A.S. Pandey is present. Behalf of respondent 1, accept notice. No further notice called for. This after 1 week. For instruction.
Will be happy after 2 weeks.
Okay, 2 weeks, yes.
Alright.
2.
May it please, Your Lordships.
Yes, Mr. Sai.
Yes, Your Lordships, this is quite a serious and shocking case. There's a recognized qualification. This is a MBBS doctor. He had done his PG diploma in non-invasive cardiology from IGNOU. That was not recognized by the then Indian Medical Council, which is a requirement of law. So through an association, litigation was instituted before the Delhi High Court, which culminated in an order of 2019, where a direction was given to the IMC Medical Council, as it then was, to reconsider this, and it quashed the refusal to recognize. That recognition fructified in an order on 3rd of February 2025. So between 19 to 25, there were several rounds of deliberations, and finally this qualification became recognized on 3rd of February 25 by an order of the central government, which the NMC was bound to follow, and which it indeed did. So 3rd of February is the first critical date where the central government recognizes this qualification. Certain terms and conditions are imposed. One of those terms and conditions are that you shall not do these sort of medical procedures on the strength of this qualification. The NMC, as a logistical matter, coordinates with the IGNOU and says that you print these conditions on the diploma. As a matter of fact, the IGNOU, in compliance of that, does so. The diplomas are reissued, and they are reissued in accordance with the directions of the NMC. Now what that does, it entitles these doctors to
display that qualification.
Yes, to get its registration and to display it as an additional qualification. And the reverse is also true, that if they don't, then they are subject to prosecution under the applicable rules and regulations. So admittedly, this doctor has got the recognized qualification in terms of the NMC. Now between January to May of 26, unknown to this doctor and to several similarly situated doctors, the NMC enters into some correspondence with the IGNOU behind our back, where it is the NMC's preference that these conditions should come on the front page of the diploma. Now the IGNOU says to them that this is after all an A4 sheet, so we can only fit in so much. And we have already done it. The diplomas are reissued in terms of your directions.
Okay, yes.
Now, by an order of 26th of May 26,
Yes.
which is impugned before your lordships, and followed by an order of 1st of June 26,
Yes.
the NMC has virtually cancelled this recognized qualification and directed the IGNOU to reissue these diplomas, reprint these diplomas by putting an asterisk on the first page saying conditions are on overleaf, etc., etc. And pending this entire process of reissuance and reprinting of the diploma, they have restrained any further registration of this qualification. Now, there are two issues that your lordships must consider in my respectful submission. Firstly, it is completely without show cause, completely without hearing. No one knows about...
Did these petitioners get individual notices?
No, nothing. There is a direct notice that goes to the State Medical Council.
How many doctors are affected in all?
There are roughly about the association that went to the... There were about 1,200 doctors, if I am not wrong.
Who obtained this qualification?
Who obtained this qualification between 2006 to 2013 when these were being issued.
Now it's stopped.
Yes, that course is stopped, and as a one-time measure, they were granted recognition by the central government after the Delhi High Court proceedings.
Yes.
So now they have said that you reissue these diplomas, and pending the reissuance of these diplomas printed in this particular format, no conditions are added more. It is not their case that no, now we wish to add certain more conditions, or we feel that there is a violation of this, we are reviewing this. It is only for the purposes of adding an asterisk on the first page and saying conditions apply. Please see that. Your lordship will find the impugned order straight away at... First, your lordship will see the communication that they had with the IGNOU, that's at 93. Where this is all...
Implemented IGNOU also?
IGNOU is not required, then no relief is sought. I have no problem if they reissue the diploma, reprint it for all they want to...
If you say that they went through a back channel,
yes,
IGNOU, at least to get the correct picture from them.
That I can add them, but the only issue is that the order is of the NMC straight away. Page 93, your lordship, is the first communication that we have found has gone to the IGNOU. Now your lordship will find at para 3.
Yes.
While the letter under reference, so far as endorsement of the terms and conditions as mandated by the Ministry of Health and Family Welfare, order dated 3rd February 25, it was requested for placing, stamping an asterisk mark after the name of the qualification with the endorsement on the bottom of the front page, mentioning detailed terms and conditions restrictions on the backside or a similar suitable statement. However, IGNOU, while their response dated 26 February 26 had mentioned that the PGDCC and non-invasive certificates were reissued as per the NMC letters dated so-and-so and dated 9/4/26 in compliance of the Ministry of Health and Family Welfare's order of 3rd February. So it is already done as on date of writing of this letter. However, the said communications did not specify that the conditions were required to be printed on the front side of the degree diploma certificate, or that asterisk was required to be placed stamped on the front page with a corresponding endorsement at the bottom thereof, and hence IGNOU reissued the diploma in its standard template with the prescribed terms and conditions printed on the reverse side of the degree diploma certificate. And given the fact that the degree diploma bearing the revised nomenclature have already been issued and distributed to the students. It is not feasible for the IGNOU to retrospectively place or stamp an asterisk on the front page along with an endorsement at the bottom of the front page. The above contentions of the IGNOU were placed in the Internal Coordination Committee of the NMC, and it has been decided to request IGNOU to place, stamp an asterisk mark on the name of the qualification diploma certificates with endorsement on the bottom of the front page mentioning detailed terms and conditions, restrictions.
But does it effectively mean that your diploma loses force?
Your Lordship, that's what follows. That's what follows, because now on the 1st of June, the impugned order restrains the state medical councils from registering this till the time IGNOU now reprints it. So in essence, they are not stipulating. I would have understood for a moment, if I am to argue against myself, that they are imposing certain additional requirements.
Right.
For the sake of argument, I'm assuming that they can.
Cancellation of your
so
recognition. Yeah.
Ultimately, what is happening now is that NMC sitting there is deciding that today I want an asterisk on the front page of a diploma. Tomorrow I want it in font 14. Day after I want it in Times New Roman. So this is not the regulator's jurisdiction or the proper exercise of any jurisdiction that I may assume that they have to do so.
Yes.
And what is the consequence of this, Your Lordship will find over the page at 95, which is the direction impugned before Your Lordships. Para 2 is a paraphrasing of what I
want to understand is how does what is the effect of just placing asterisks and placing those qualifications? What will be the impact on the doctor's practice, or whether
it does not? They are saying it,
and that you say that these people have attained qualifications prior to 2013.
Yes, all of them. This person is 2014 before Your Lordships. This course was run between 2006 to 16. So around 1400 doctors participated. They got qualifications, and thereafter it became a case where the IGNOU, a central government university, had given them this qualification, but on the other hand, the left hand was not recognizing the right hand. So we had to go to court for that through an association of these doctors. But that is now behind us. The doctors have received recognition. Now the question is whether they can stipulate a asterisk, a comma, or a full stop. And pending that, what they do is at para 4 of page 95.
Yes.
Para 3, sorry. As such, the additional qualification registration of qualification postgraduate diploma in clinical cardiophysician non-invasive will be done after reissuance of certificates by IGNOU as per the requirements of NMC. All the state medical...
They have to re-register.
Now they have to reissue further, Your Lordship.
Yes.
Few of them had registered. The doctors before Your Lordships, I must candidly admit, are not the ones who got the registration yet. But they were entitled to registration as a matter of legal right. Yeah. Now what happens is at para 4, all the state medical councils are hereby informed not to register the said qualifications in respect of any applicant till further communication from NMC. If any state medical council has already registered any applicant, the same may be cancelled. So 12 poor doctors who got the registration, their registration is cancelled without show cause. And for the rest of us, 2 of whom are before Your Lordships in item 2 and 3, there is a restraint on registration, all for the purposes of putting an asterisk. So on the 3rd of February, and please see why the anxiety, Your Lordship. On the 3rd of February 25, we get statutory recognition of our qualification. The reprinting of the diplomas takes in some cases 6 months. In the first instance, according to the original stipulations.
Yeah.
Now today, as on 1st June, if they have asked for another reprint, it will take another 6 months, 8 months. We have to then go. So this sort of onerous burden is being imposed on the doctors, and particularly in a state like ours, Your Lordship knows that the doctors are required, and there is in any case, for particularly for non-invasive cardiology, it's a very Your Lordship will also see for completeness the final order, which is also of 1st June, which is at 97.
Yes. Yes.
So para 3 enumerates the 12 doctors whose registration had in fact taken place. These are not doctors before your lordships, I must be fair to your lordships. But para 4 and 5 is the impugned direction. As mentioned in para 2 above, the already issued certificates are not eligible for registration. Hence, the additional qualification certificates have been cancelled, withdrawn, white letters dated so and so. It is also informed
Have
that
people gone to court?
Your Lordship, I am informed that some of them are going, but
any orders have been passed?
No. That I can say with some. I have instructions that no such orders have been passed.
Yes.
But before your Lordships, I am more concerned with para 5.
Yes.
All the state medical councils are hereby informed not to register the same qualifications in respect of any applicant, including the above applicant, till further communication from the NMC. And if any SMC has registered in respect of the above, same may be withdrawn, cancelled immediately. Now, your Lordships will for a moment consider NMC is a statutory body. Its roles, responsibilities, powers are enumerated under the NMC Act 2019. There is nothing, firstly, the impugned orders don't refer to any such purported powers. They are saying one committee thinks it fit that we want an asterisk on the front page.
No, what triggered this action?
We have no idea.
There must have been something.
None, because what I have placed before your Lordships, when these doctors got the 1st June letter, which was circulated to all the state medical councils, is when we came to know that in fact such a thing was happening. I understand that perhaps the purpose is to give full transparency to the patients, that yes, there are conditions on the overleaf and we have no dispute. So for that purpose, I am saying before your Lordship, let the IGNOU reissue diplomas. I have no problem with that. But that can take any number of months, and the pending that the registration should be permitted. Because otherwise then I am left in a limbo that I have a registered qualification, I can't use it. I am subject to all sorts of prosecution, right from the PNDT Act to, because these doctors, your Lordship, for context, they operate echocardiograms. They operate echo machines, etc. They are not invasive cardiologists, only non-invasive. So those attract the PNDT Act registrations, etc. Also the preconception, prenatal diagnosis.
Has the petitioner applied for registration?
No, he has not applied for registration. He has not
State
applied.
Medical Council, no.
Yes, he has not applied for So two things before your Lordship, because it's per se without jurisdiction. Per se,
but it's not only confined to these two people. It's a larger picture.
That's right.
That's
right.
the only thing.
That's right.
What is the?
That's right. And so your Lordship, there are now, in the context of what I placed before your Lordship, for the present I am seeking at least an interim relief where at least the order
Effect the circular.
Yes, this effect of the circular has to be stayed. Your Lordships may balance the equities, may say that IGNOU may carry on with the reprinting.
Yeah, Dr. Mozika, you're attempting to be out.
Well, I'll require instructions for it. But in my
you're waiting for whom?
I can file affidavit number 1 and 2 I've been served copy.
In for this one National Medical Commission and
Ethics and Medical Registration.
Yes.
And
third is Meghalaya State Medical Council.
It's represented by whom? By the state council? No.
I thought Mr. Pandey is appearing.
No,
Pandey appearing for 3.
He is appearing item 3 for the petitioner. Oh. He is on the same side as I am.
Okay. Yes.
Madam, my only submission, Madam.
Yes.
Let me file an affidavit, Madam, as soon as possible. For 1 and 2.
No, because the picture is large. It's not confined only to these two people. And
any interim order at this stage, my lord, will amount to grant.
No, even then, but the thing is that if, basically, if they've not even been given notice and if it affects them, it's affecting their profession.
Degree is obtained in 2014, my lord. Till now, they have not been granted registration.
The 2014 is the original diploma, reprinted in 2025 because we got recognition in 25. I have the reprinted diploma. I placed that before your Lordship.
So you mean to say that the courses were over?
Over in 16. Yes, in 16.
And they must have got some kind of diploma for that.
They got a diploma whenever they passed this petitioner before.
Again.
So that was not recognized. Yes. As it stood, the MCI then said that IGNOU is not competent to run such courses. We contested that through an association before the Delhi High Court of all such PGDCC doctors. the decision of the MCI not to recognize was quashed, and a direction was given that you consider it. After all, it's a central university, it has the competence to award degrees, and this is a full-time course. They have done it attached with hospitals. There's proper course content, and it was the Ministry of...
I was wondering of how can, you know, an open university...
No, so it was...
Correspondence, can you...
That was my first question.
Diploma holder in cardiology.
And I was on record with them in 2016 when we got the order in 2019. So these questions fell even from the court even then. But this was a full-time course at par with AIMS and promulgated by the ministry itself.
Yes.
So the left hand refuses to recognize the right hand. The MCI says that now what Ministry of Health has done, we will not recognize. And now that journey from 2006 has culminated in 25. Now they are saying reprint the diplomas.
Yes, what? Yes, Dr. Mohit,
But any interim at this stage, because this is a larger issue, as submitted, 1200 doctors are affected. Any interim order at this stage? Let me have instruction that the matter can be taken up next week.
For interim orders?
Your Lordship, I would respectfully urge, because I do not oppose the filing of a response. Of course, there's a right. But the question today is, on the face of it, if they can show even a single section.
Copies?
Yesterday.
The state medical...
Can you obtain instructions by tomorrow?
Tomorrow will be difficult. The National Medical Council,
I can demonstrate.
I'm not very clear also whether they have their own panel council also. I don't know.
They do that, as a matter of fact. I checked up. But on the face of it, not a single provision. I'll show your Lordships the NMC Act also. If your Lordship finds that there is a semblance of power to do this is after all a statutory regulator.
See, the only thing is that if it already been registered, there's no problem of staying, you know, the recognition or cancellation.
Yes.
But in this case, not registered as yet.
I follow that, your Lordship.
So that, therefore, so whether we can issue interim orders as saying that, you know, it shall not prevent you seeking registration at this stage.
Because
so when a matter is heard, when after the been filed, maybe okay. But now at this stage, whether now your people are such a threshold, right, and you're seeking reliefs, that you know that it not be they recognized. But now it's still registered with the State Medical Council.
Yes,
that's correct.
Yes, we are.
Then,
but the problem is this, your Lordship. I ask myself this question because after all, asking for an interim relief from the court, it must be something that can be feasible, workable. But the question today is that what is the net effect of this order? My recognized qualification is no longer recognized till the IGNOU now reprints it with an asterisk. So that legal right,
how fast they can
do it in a week, 10 days. That is not an issue.
I can have instruction of that, matter. But
that apprehension, they may do it in a week, and that's why I'm saying to your Lordships may obviate that, may say that IGNOU will try and expedite. Your Lordships,
that will be the final relief.
Yeah, so
that will be final consideration.
Or your Lordships may say that pending this proceeding, the IGNOU is not prevented from reprinting the degree or diploma.
Let me say hi. The counsel with the petitioner issue notice of the University College JTI with MSc Jalas present on behalf of respondents 1 and 2.
Yes.
No further notice on the said respondents. Notice to issue to respondent number 3 within 3 days. The grievance of the petitioner here is with the impugned circular dated 26/5/2026. and impugned letter dated 1/6/26 issued by the respondents number 2.
Yes.
Number 2, whereby directions have been issued to all state medical councils not to register the additional qualification of, it's called postgraduate diploma in medical cardio-physician
in bracket non-invasive.
Yes, obtained from the School of Health Sciences, IGNOU, in respect of any applicant till further communication orders. Next paragraph. Ms. S.I. Submitted that this requirement, which has since been imposed by the circular and the note and the letter dated 1/6, has adversely affected the rights of the petitioners, inasmuch as, firstly, no notice was ever given, or the petitioners aware about such a requirement which is contained in the said circular. He further submits that the asterisk where that submits that the directives, the directives issued by respondent number 2.
At para 4 in the letter dated 21st May 2026 at page 93.
Oh, no. Yes, as seen in the letter dated 26/05/2026.
Yes, Your Lordship, para 2. Yes, para 2 of the 26th May impugned letter.
Yes, sir. In para 2, is this impugned? Is P17?
Yes, P17 is impugned. Not P17, P18 is impugned, and P18 also contains that.
It is in fact 7 and 8.
P8, sorry.
Yes. Yes.
Because it is in fact P7 and 8. It seems 17, but it's a dash between P and 7.
Sorry.
Oh, P7, okay. Yes.
Impugned is P8 and P9.
The directives issued by the respondent number 2 are contained in the impugned is a circular, right?
Yes.
Dated 26/5/2026 and the letter of the same date, which requires the IGNU to place or stamp an asterisk mark after the qualification with endorsement on the bottom front page, mentioning the detailed terms and conditions/restrictions on the back side, or on a similar suitable statement. He submits that this requirement being odious. That is your submission.
It's without jurisdiction.
Yes, without jurisdiction is liable to be interfered with by this court. He therefore prays an interim that the circular and the letter dated, the circular dated 25/6/2026 and letter dated 1/6/26 be not given effect to until the next date. Yes. Dr. N. Mozika, Leonard, PSGI. What's his submission?
My submission is that no interim order is called for. I'll file affidavit in the meantime.
Praise that the
amount of
constitutional interim order may be considered next date, and that he may be allowed to obtain necessary instructions in the matter or to file
especially because they are not yet registered.
Yes, especially the account is not registered. Stop having heard the counsel for the parties and on examination of the materials as placed before this court, it is noted that the first stage submission of the counsel's petitioner, that the effect that considers that the petitioner was not put to notice in a matter that would adversely affect his practice and impending registration. Further, it's also noted that the requirement as spelled out in the impugned letter is only for the asterisk, which is an asterisk to be placed to with certain conditions. What is that? Asterisk to be placed.
That conditions are on overleaf.
Yes,
the conditions are also there. It's just to say that please turn the page.
Be mentioned there in overleaf. So, these requirements in the considered view of this considered view of this court at this stage, though appearing to be innocuous, however, would surely have an impact on the practice and the proposed registration of the petitioner. Accordingly, a prima facie case will be made out for. We will see that no course of action be taken against the.
Your Lordship may stay.
Yes, it will be made out for interference at this stage. So it is provided that the next date the impugned circular and ordered and the letter dated 1/6/2026 as far as it pertains to the petitioner shall not be given effect to. Yes. There will be a floodgate.
I'm not able to appreciate the purport of this interim order.
Yes?
I'm not able to understand the purport of this interim order.
Of the?
This interim order.
No, I mean, as far as the petitioner concerned, it will not be given effect to.
Yes.
That means not to, because see, this 1/6 contains that means other doctors were registered.
Yes.
So as far as
that will virtually mean that we have to register them now. during
No,
the
no, no.
pendency?
You come with instructions. It goes after 1 week.
At least in this interim period, nothing will happen against me because of the fact
Because they are not even registered, my lord. As on today, they are not
that is
registered
what
in admin
it's,
position.
see, if they that's legitimate expectation that you have, right? They will register.
Yes.
1 week, nothing will happen. This is matter after 1 week, the fixed matter.
But the interim order, as far as the petitioner, for the petitioners,
It's for the petitioner only.
Yeah.
does not come, my lord.
It's confined to
It
petitioner
has
as far as petitioner is concerned. Yes.
That will be
Yeah.
for the petitioner.
I'm so grateful to your lordships.
Same orders will also in item 3.
Yes.
Item 3 is
Same orders.
identically placed.
Identically placed.
Yes.
I'm okay.
Okay.
Oh,
Who was appearing in this matter?
District
Where's
Council.
PS Nongri?
Lordship, in the last date we have served the copy to them, and they have given a submission.
No,
for this court.
where's the respondent? MSP of Karavana, Miss Case submits that notice has since been served, copy has since been served on the respondents, but however there is no appearance on their behalf today. We listed on Monday, if the matter on Monday, because we'll allow this petition, but they have to be present.
Let them know.
Yes.
Highly obliged.
5.
His Lordship, yesterday I was asked to place this notification, my lord. This is the rule for distance, Lordship. Lordship has asked. And then
More importantly, Mrs. Chan, you studied the matter, Mrs.
yes,
Sama.
Lordship, this
My lord, the lordships have decided a similar issue, my lord, sometime last year.
kindly see the
Last year.
rule 1.
1 second, 1 second.
183.
See what a judgment was passed by the court last year.
My lord, the relevant paras from para 9 onwards. My lord.
Yeah.
My lord, here the facts of the case was that the NOC issued by the headman was recalled to the effect that there was an objection raised by the residents of that particular area, my lord. In this circumstance, no, if I may read, para 9. In these circumstances, this court is therefore to examine as to whether any rights of the writ petitioner have been violated or whether a mandamus can issue to direct the respondents to allow the lifting of the liquor and the petitioner to operate the business as per the license granted. Concisely put, the issue crystallizes only on the point of the grant and recall of the NOC with respondent number 6. Though this court had made an attempt to obtain the proceedings or records, which culminated in a decision to grant NOC, which is evidenced by the acceptance of a fee to the tune of rupees so-and-so by the respondent number 6, the same not being made available has hampered this court from arriving at a clear decision on the question of whether public opinion had been sought. No doubt proceedings to recall the NOC by the Darbar have been made available. However, in the absence of the Darbar, therefore, the considerate view of this court needs to be revisited. Now, my lord, if lordship recollects, this court has directed the deputy commissioner to convene 2 meetings.
Where?
My lord, they are directed the deputy commissioner.
In this matter?
In this matter, my lord, in the instant matter. In the context of the necessity of public opinion in such matters, it would be necessary to refer to the provisions of the Meghalaya Excise Act as adopted by the Meghalaya, which has laid down procedural safeguards in the issue of licenses for retail liquor shops. Now, my lord, the relevant provision, section 28. It says ascertainment of local public opinion. Then again, my lord, the rule 191, which mandates that the opening, shifting, amalgamation and closure of any license shall be done by the district collector with the provision sanctioned by the state government. Such opening, shifting, amalgamation and closure shall not be granted unless it has been satisfactorily established by local inquiry that the proposed action is necessary in the interest of public, and until any objections which may have been filed on the subject have been considered by the district collector. A perusal of the above noted provisions thus clearly mandates the ascertainment of local public opinion with regard to licensing and location of retail establishments, as also the opening, shifting or closure
wherein objections from local bodies ought to be considered and consent obtained before grant of license. In the instant case, the mandate of the above noted provisions had been complied with in the ground of bar license to the writ petitioner, which, however, due to later events, has resulted in the same being kept in abeyance of the ground of recall of the NOC. It is noted that in the recall of the NOC, the writ petitioner was not afforded any opportunity to put up his side of the story and was only informed on his query about the developments, which has now resulted in the suspension of his business activities apart from causing heavy financial losses. Thus, as observed earlier, as it is only on the objection of the community that has resulted in the deadlock. However, it must be kept in mind that trade in liquor is not an enforceable fundamental or absolute right, and the right to trade is considered a privilege granted by the state under relevant law, as the same is a state subject and not an inherent right of citizen. Any trade in liquor, therefore, can only be carried out under the specific terms and conditions of a license granted by the state respondents, which are subject to stringent control. In the totality of the circumstances, therefore, taking into consideration the facts discussed here and above, moreover, the legitimate expectation of the writ petitioner to operate his business on the license being obtained after due process, notwithstanding the settled position that there is no vested right involved in the trade of alcohol. Now, here in the said case, this court on the balance of equities has issued several directions, my lord. No, but here, my lord, it is.
What happened after that? Is he running the restaurant now?
No, my lord.
What happened? This order only directed that the shall convene a meeting and to revisit the cancellation NSC, especially with regard to opinion.
Here, the directions given by the court.
Now your case is one step ahead.
No, my lord.
Your case already is, there were a lot of objections, right?
No, my lord, even before the NOC issued by the NOCMA, there was an objection from the public. Despite that, my lord, the NOCMA has issued the NOC.
No, in your case, what has happened is already, the thing is, firstly on the distance, correct? Here the distance was an issue. Okay.
Well, here more or less, because here he has obtained all the relevant criteria. He has obtained all. With regard even to
so what happened after that? This case is open-ended. The only direction is that
yes. No, but
anyone knows, no.
No, but this court taking into consideration the provisions of law has directed the parties to.
In your case, already gone one step further. It's already directed. I think there was already a meeting convened.
Well, yes,
where you had appeared. We can see your statement what you said in the meeting. You said annexed in the petition. Where? Or the meeting affidavit?
The meeting was actually that was filed by the state respondent. There is a meeting that after there's kindly have the meeting. This is the meeting on 19. It is that meeting also is reflected on the order 26/03/2026. Now,
please slow down.
Yes. Lordship, there is a meeting on the by the president.
No, when? Which order? Which order?
Lordship, there are two meetings, Lordship. Lordship, can we have first day of
16/12/2000.
First report, Your Lordship. File on 11 February 26.
Where there is affidavit?
No, Lordship, this is only a report, Your Lordship.
Manoj will have the order dated
16/12/2025. So there is a direction for to have the meeting.
One at a time.
Yes. Then
where is the?
Then there is another order, my lord.
Second, Mr.
Lordship.
Just relax. We're just trying to examine your matter. This is the 4th February 26.
Yes, Your Lordship. This is a report of the Deputy Commissioner.
Yes.
In pursuant to the order dated 16/12/2025, Your Lordship.
Yes.
Lordship, can you see?
Yes.
Lordship, kindly see the second paragraph from the bottom in that.
Yes.
As per query report from Same Magistrate, Annexure 2, the shop was fulfilling the legal requirement.
Where are you reading from?
Lordship, from the letter dated 4/2/26, Your Lordship. Page
Not
1 of the
annexure.
report. Page 1 of the report, Your Lordship.
Okay, yes.
Page 1 of the report, Your Lordship. As per inquiry report from Same Magistrate, the
Yes.
shop was fulfilling their legal requirement as per Meghalaya Excise Act. Further, an inquiry in the matter was conducted by the Inspector Excise on so and so, during which it was observed that the establishment of the IMFL shop at so and so fulfill the prescribed legal requirement under the relevant laws or rule. However, as per report from so and so, there exists strong objection and opposition from the representative of the local development committee, which also supported by the local pastor of the area. Further from the inquiry report, it is seen that in the meeting with local, only 26 people were in favor and 72 were against the wine shop. It is further reported that till date, no law and order have been arrested the concerned locality to the fact that the shop has remained non-operational for a constant period. Accordingly, the possibility of law and order cannot be ruled out. In view of the above, and in order to make peace in the area, to the following assessment is presented from the undersigned. There is no law and order issue in the shop since the shop has been closed for over a year. There is a possibility of law and order if shop is permitted to. However, it is clear that if there are strong assessment of law and order erupting due to the opening of shop, if it is allowed, then the district commission may be allowed to close it to make it peace and preventing any danger to sale given the nature of flammable content in the shop. Since there is strong, it is clear that the said wine may be allowed to ship to some other places where no public operation is there under rule so as adopted by the Meghalaya. Then, Lordship, subsequently, Your Lordship, another meeting also was held, Your Lordship.
This was held on?
Lordship, kindly have the affidavit filed on 7/4/26. That is in pursuant to the order. Affidavit 7/4/26, Your Lordship.
Yes.
In pursuant to the order dated 23/3/26. If Lordship, I take Your Lordship to Annexure A at page 7.
Yes.
This is the meeting, Lordship. Then Lordship, kindly have a page A.
Yes.
Lordship, I'm already the representative of the Tura Municipal Board. Tura has clarified that Walbakri locality does not fall under the municipal area and therefore is not under the jurisdiction of any development committee. The shop is approximately 200 meters away from the Tura Town Church and Nixeng Jitim Church, and the nearest educational institution, and at least 300 meters away from nearest development committee. The development committee whose members were present in the meeting as complaining against the shop.
Yes.
So, Your Lordship, it appears, Your Lordship, that the shop is at a distance of
more than 200 meters. Yes. It complies with the requirement. Then, when was this? When is other shop? This other. Read the other paragraph.
My lord.
That regarding the question of bootlegging, rampant area complaints acknowledge the problem. Yes.
Regarding these issues also, we have filed a complaint before the.
Yeah, you can't blow hot and cold.
No, my lord.
You have objections. I think Mr. C. Samba, that case you placed will have not a relevance here.
Lordship, kindly have a rule 183 through your
regarding the question of a shop 105 meters away from the wine shop. Are you advocating the cause of other wine store to stop the opponents of other wine store?
I'm being one of the residents from the Walbakre.
You don't. Your Walbakre is away. Even this church is 200 meters away. Even the Tura Town Church, and both the churches are 200 meters away. And also that your development committee has no say because it doesn't fall within the Tura Municipal Board. It must fall within municipal area. So what is your objection? You are 300 meters away.
Lordship, kindly have the rules, Your Lordship.
What is your objection primarily? And then why are you allowing? Then why do you give the blessings to another bar?
With regards to the restaurant cum bar, as I submitted yesterday also, we are not aware whether the restaurant was running a bar. That's why, with regards to that, we have filed a complaint.
When was it opened, the bar?
My lord, kindly have my affidavit, my lord.
Lordship, kindly have section rule 183 2, Your Lordship.
Yes.
Lordship, this has been amended. Lordship, kindly have a page 2. This has been amended by in the year 2015, Your Lordship. Kindly see, Your Lordship, 2A.
Yes, the 200 meters.
200 meters. Then, Lordship, kindly have page 5, Your Lordship. This is the amendment of 2018, Your Lordship. This 2018 will not be applicable in the present case, Your Lordship. Explanation for Rule 2A, Your Lordship.
What are you submitting?
So, Your Lordship, as it revealed from the report of the inquiry, a meeting held by the Deputy Commissioner, it falls within above 200 meters, Your Lordship. This 2018, Your Lordship, it says that in rule.
Yeah, it opened before 2018. Yes. You'll have no application.
Then, so far, the contention.
Now, what about the distance between the bar and the new wine store? Any restriction?
My lord, against the bar also we have filed a complaint.
When did you file it?
Just subsequently, my lord, after the emergent meeting, my lord, that will lord.
This
can
is
I have my affidavit. My lord?
That did not
My lord, can you have my affidavit, my lord? Page 43.
Mr. Sangma, I'm sorry with the conduct of you people.
Lordship,
you can't bless one and curse one.
No, can you have page 43?
Yes. If you look at equity or you look at Article 14, can you
Lordship,
bless
for the
one
moment,
and
if
curse
Lordship kindly have Rule 191, Your Lordship.
Yes.
Lordship kindly see B2I, Your Lordship. Admittedly, Your Lordship, it reveals from that it does not fall within the municipality, Your Lordship. Lordship kindly be B2I. Then the Lordship A. In the case of areas not situated in a municipality, town committee, owners, or occupier of land. So, Your Lordship, admittedly, Your Lordship, here in this case, Your Lordship.
Where are you reading from?
Lordship, I am reading at 191 B, Your Lordship, B. Then 2
B.
1, Lordship, 1 B.
What is saying 2I just now? What's 2I?
Then B, 2I is there, Your Lordship. In the case
B,
of areas.
2I?
Your Lordship,
B2A you mean?
Yes, Your Lordship. In the cases of areas not situated in a municipality, town committee.
Yes.
Yes,
we'll hear Mr. Sangma. What do you have to say?
No, no, kindly have.
What is your main objection? Apart from the moral ground.
Look, here within, just to take. Here within.
Firstly, the thing is that under the Act you have no case.
No, look,
because both the churches after inquiry is more 200 meters away, right?
But coming to in terms of section 28 and rule 191, I am very much there, my lord, because we have been opposing.
Opposing for the sake of opposing. Suppose now you oppose opening a shop somewhere in Upper Shillong, you go and put your objection and say I'm opposing it. Some shop should be closed.
No, that within that's outside my jurisdiction. But here,
now see the report that page 8 of the affidavit of file on. That's the last affidavit place. Read these two paragraphs.
Well, yes, I've gone through the reports.
Then?
Now, let's kindly have my affidavit, page 43.
Then, what if as responsible citizens, what have we done against the bootlegging?
Against the bootlegging, also, we have filed various complaints before the SP, before the.
What have you done as a society? Have you gone apprehended the bootleggers?
To that extent, I have to see whether they have. But I think I have been informed that they have been tackling all these issues.
Who's been tackling?
The development committee and the residents.
The development doesn't come to picture here.
No, the development committee is a registered society, and it comprises all the areas.
You can't be dogged in manger. You see, if there were no bars out here or no restaurants or no wine stores, we can understand. If we are trying to enforce total prohibition in that area, see, okay, fine, church might be 200 meters away, but the thing is that what stares the court in the face is that all along a bar's operating a restaurant with your blessing, it's going on, and then finally when a person has got a valid relocation permission from the authorities to relocate to the other place, then he comes with objections.
No,
is it proxy litigation? I hope it's not. It is.
Can we have the page 42
of your affidavit?
No.
Yes.
Page 43.
45. Yes. Yes.
43, this is the minutes of the meeting held on 14/5/2026.
Yes.
The third last paragraph, agenda number 2. Since it was the responsibility of the respondents to respond to the High Court proceeding, the committee so-and-so. Next paragraph. The Secretary further informed the members that among other allegations mentioned in the complaint submitted before the High Court.
Where is that reading?
The minutes of the meeting dated 14/5/2026.
Where is the next?
3. This is the transcript.
Page 45 is the list of members.
Page 43, my lord. This is the translated copy.
Yes.
And can you have the
The meeting was held on
14/5/2026?
Okay.
Can you have the second last paragraph? The secretary further informed the members that among other allegations mentioned in the complaint submitted before the High Court, the petitioner alleged that the Walbakar Development Committee acted in biased manner by allowing the restaurant located about 100 meters away from a wine shop to operate a restaurant and a bar. The members discussed the matter at length and finally resolved that the people of the locality and the developer have not received any complaint regarding the operation of the said restaurant. The committee also stated that it was unaware whether the restaurant was serving alcoholic beverages to its customers and clarified that no objection certificate have been issued by the committee for opening a bar at the said establishment. Therefore, if the allegations made by Srimati Soto are found to be true, the members resolved to submit a petition to the Deputy Commissioner requesting necessary action, and if found guilty, appropriate steps should be taken. Pursuant to this meeting, on 4/6/2026, that's page 46, annexure L, a complaint has been filed before the Deputy Commissioner Excise.
So it's been closed now, the shop.
And now I think they have been called. The inquiry has to be done, my lord.
This is the after only when court has interfered.
It came with a court interview. It came to the final inquiry report by Deputy Commissioner.
No, my lord, even from the various reports submitted by the DC itself, says that the situation of law order cannot be sidelined. And secondly, my lord, the objection.
Yes, the rule of law has been maintained also, Mr. Sangma. You can't have two standards. Now you can't have an afterthought of a meeting, to try to wash your, to improve your case. You can understand if you have consciously all along been, even given NOC or whatever, blessed the bar that, you sought to revoke it. This was in the earlier case, exactly the case. Because NOC is given not the knowledge of, and then otherwise it was revoked. Anyway, we'll pass orders. Yes, Mr. Sangma.
That is only thing court can. Yes. That is only thing I have to say that.
Daily list item number 1.
Apply, Your Lordship.
Yes.
This Lordship, this is the petition, my Lord. Let me just. This is for appointment of the pre-primary teachers, Your Lordship. That whereas the law is very clear, Your Lordship. First, let me take you to the Lordship, to the page 22, the provision, and also the notification issued by the Director of School Education Literacy, page 29. Before that, let me page 22. Now the criteria laid down by the NCC.
The NCC?
Yes, NCT norms, my lord. The type copy.
1 second, where is that? Where the private respondent?
Private respondent, there is various order has been passed, but there is order.
Private respondent, it has proceeded ex
She is
parte.
appointed.
She's already been appointed, Your Lordship.
She has been appointed, but
she'll lose her job.
Yes, there is order also that subject to the outcome of the repetition, that order has been passed.
Wonder why she's not.
And she is not contesting.
Served.
Yes, despite 2-3 order has been passed, Your Lordship.
By personal service also?
Yes, this has been so. No.
The school, which school is this?
This is the.
William
appearing for the school.
It's a pre-primary school, Your Lordship.
School, the governments are appearing for all the respondents.
No, you didn't make
For
the
1 to
managing
3, I'm
committee.
appearing, not for the private respondent.
Who conducted the interview?
The interview board, Your Lordship.
Of the managing committee,
Your
then?
Lordship.
Mr. Sangma, you didn't implead the managing committee.
Managing committee.
And let me see. This one is done by the interview was done by a school education officer, my lord. And he has
correct.
replied the legal notice.
No, where's this?
Your Lordship,
interview board, where is it? Let's see.
In their
Who screened the application? You say she is not qualified. Yes.
Kindly see the.
They claim to this post is only because they've secured 49% in class 12, Your Lordship.
No, his ground is that she is not qualified and she was called for interview and she was appointed in spite of he being qualified as per
But
NCT.
on a comprehensive assessment of all other criteria,
but
Your Lordship, her marks are higher than that of the
but she passed
petitioner.
the cutoff mark. Did she have them?
She had
As per NCT
45%, Your Lordship,
as a cutoff.
in class 12, Your Lordship. For SC,
I have
ST, it
49,
passed
she not reaching 45, she got only 42 somewhere. It is mentioned
only 42.
the private respondent, yes.
So it's a little less than 45,
Then
Your
how was
Lordship.
she considered?
Because they
Because
say
of the over...
Who? Okay.
Actually, let us...
Please, who screened the applications then?
it is a school
Management
education
committee.
officer.
Sure. Where is it?
My lord, there in the affidavit of the state respondent, kindly see the page 14.
Where in your petition?
Yes.
Where's the appointment letter?
Appointment letter, it's not, it is with the office of the respondent, with the state respondent.
Where's the result of the interview? Who notified it? See, Mr. Sama, you have to come in a logical fashion. Whether who conducted the interview, who screened the application?
It was conducted by the school divisional,
The
sub-divisional school education officer,
Where's
William
the-
Nagar, East Garfield.
Where the interview conducted by him? Where can you show that?
Yes, Lordship, the interview, the result, it is there, Lordship. I've enclosed it.
Even the advertisement.
Page 43, my lord. Personal result of the interview. Page 43 of my repetition.
The interview was conducted by SDSU.
Yes,
Correct.
sub-divisional school education officer, William Nagar, East Garfield.
Yes, Your Lordship. Yes, Your Lordship. I'm sorry.
Not the managing committee.
Not the managing committee.
Managing committee is only
Not a managing committee. So in the result, is based on the performance of the candidate in personal interview conducted on 17/01/2025 in the office of the chamber of the sub-divisional school education officer, William Nagar. Below, given candidate has declared to have passed successfully in the personal interview for the post of assistant teacher, primary teacher of Sisubibra Government LP School under East Garfield district in order of ineligible as recommended by the board of interview.
Okay, yes. Start, yes.
So now my contention is, my lord, since there is a rule where it's provide page 22 of my repetition, the type copy, it's clearly mentioned page 22.
Yes.
Of my repetition, my lord. The original copy is a page.
Okay, no, yes.
17.
Minimum academic and professional qualifications.
Yes.
Preschool, nursery for children age group 4 to 6.
Yes.
So you need one senior secondary class 12 equivalent.
Yes.
From both the 50% marks, or senior secondary class 12 equivalent from recognized board with at least 45% marks in accordance with NCT.
National?
Yes.
National
Okay.
Council Board. Now my case is, my lord, then after
and diploma industry.
Yes.
You need diploma also.
I don't have diploma, Your Lordship, but at least I have the 49% of marks.
Stop pressing in the 49%. We look at the criteria whether even the petitioner meets. See, and diploma industry teacher. Anyway, continue. Yes.
Then I will take you to the Annexure 2, page 29, my lord, where the Director of School Education and Literacy, Meghalaya Shillong, have issued the letter dated on 26 July 2018. It says, page 29, my lord. May I read, Your Lordship, the relevant part. In continuation of this office order letter, DSELELG so and so, dated 1/04/2015, and in pursuance to the letter under reference is issued by the National Council for Teachers Education, New Delhi, the prescribed minimum qualification for appointment to the post of teacher of pre-primary school, preschool, nursery school is indicated below. Now it is, it is, my lord, in the column it's a preschool nursery for children in age group of 4 to 6 years. Now it's written class 12 50%, then bracket, comma, 45% SC/ST. Then
okay, fine. Now, what does "and" diploma means?
And diploma in necessary teacher
Not necessary, nursery.
Yes, necessary. Now, of course, in this case, Your Lordship, both a candidate, even
They don't have this.
we
They
don't
don't
have,
this qualification.
even the private respondent
Now,
have
okay,
the
firstly, the private can does not have 45%.
no.
She has only 42%.
42%.
Undisputed.
Yes, undisputed.
42%. And the other requirement, diploma, none of you have it.
Yes, none of
you
us
have 49%.
only 49%.
Okay. That means no diploma.
No diploma.
Yes, continue, yes.
Then, Lordship, thereafter the result, I have taken part in the interview, and the result was.
How many of you were called for interview?
There are exact number I don't have,
As
but
per
there's many.
instructions, Your Lordship, only the two of them were available for interview.
Only two of them.
Yes, Your Lordship.
Okay, then.
As per instructions.
Yes, only two of them, but then the private respondent got selected, and thereafter I have submitted a number of representation to the subdivision of school education, and also to the director of school education literacy Meghalaya Shillong on different date. I also approached the commissioner and secretary to government Meghalaya education department.
Very good. You done all that. What happened after that?
See, after that, there is no response.
When was private respondent appointed?
The private respondent is appointed, my lord. They have mentioned. That's right. Review and school given in the recent certain penalty. He has been appointed 45 make it a very recruitment procedure. They have the point of you have not mentioned that when he has appointed and date of appointment.
But the selection happened which year?
Even their affidavit they have not mentioned because the recommendation they have next, my lord, the page 20 day he was appointed on 21st January 2025.
Yeah.
1 day after the interview.
Yes, Your Lordship. 17th was the interview.
It's contractual or it's permanent?
Contractual.
It's not
contractual then?
Not the contractual. It's not contractual. It's not contractual, my lord.
The interview was held on the 17th, Your Lordship. As per our score sheets here.
Yeah, the result taken 20th and
17th January, Your Lordship.
Performance candidate interview school education with another candidate. As per the instruction which I am pleading, this is not a contractual, it's a permanent, my lord. Not contractual.
We get a consolidated payment.
Purpose of assistant. It's not contractual, my lord. Purpose of assistant teacher, pre-primary school of Sisubiro school under is Garvey District Meghalaya.
Consolidated payment.
Condition of the penalty appointment.
No, that is where the relaxation is.
What about the annexure 3 of the affidavit then? Can you read that?
Annexure 3. Okay. 3. It should be qualified in all respect.
Read this annexure 3, page 13 of the affidavit.
With reference to subsection to inform you that priority should be NCTE qualified teacher.
No, read up further, yes.
Teacher, and all steps should be taken to ensure the same while going ahead with the recruitment process. However, as this is the contractual post and in your remote area, it may not be possible to get the NCTE qualified candidate for pre-primary. In such cases, the next best alternative can be recommended teacher qualified to each in elementary section as per NCTE.
What's elementary qualification this week?
This is only after after appointment only appointment this one. But here also they have given the preference should be given to the NCTE qualified. At least I have fulfilled one criteria of the NCTE. The private respondent have none. He don't have neither. He obtained at least 45%, nor she has got a diploma. So,
what do they mean by this elementary qualifications? Mention this
Must
letter.
be regarding pre-primary, Your Lordship.
No, just read this letter.
Yes, Your Lordship. We have attached it with the affidavit.
Yes. The last line.
Yes.
See, in such cases, however, as there's a contractual post.
Yes, it is a good. And in
but
rural
appointment
areas,
doesn't reflect like that. And in rural remote areas, it may not be possible to get the NCT qualified candidate for pre-primary. In such cases, the next best alternative can be recommended. Teachers qualified to teach in elementary section. What are qualifications necessary for elementary section?
as per NCTA, may be recommended in such
which
cases.
is the kindly show where for elementary what is the qualification necessary?
Your Lordship, first, has my friend submitted?
is it the elementary have submitted? The elementary is not mentioned. The rule is very clear, my lord.
Elementary section means classes 1 to 8, Your Lordship. Elementary school.
Then how?
But those who are qualified to teach in elementary section as per NCTA may be recommended.
The submission application determination.
Elementary education in India refers to the first 8 years of formal schooling for children aged 6 to 14, Your Lordship.
Then I can't understand this letter.
Lordship.
See, this is he writes with reference subjects. I am to inform you that priority should be NCT qualified teachers.
Yes, Your Lordship.
And all steps should be taken to ensure the same while going ahead with the recruitment process. Now, firstly, the respondent fails in its first threshold percentage.
Yes.
However, as there is a contractual post and rural areas, it may not be possible to get NCT qualified candidate for pre-primary. In such cases, the next best alternative can be recommended. Now, both of them don't have diploma.
They don't have diploma.
They're on equal footing. The other one doesn't have diploma, does not have the qualification NCT.
But overall merit, Your Lordship,
merit then?
as far as teaching skill is concerned, superior aptitude is there, Your Lordship.
How? Where? Let's see.
Yes, and Your Lordship, there is a power to relax also. As per this NCTE rule, Your Lordship, of 2014, at page 17, Your Lordship, which is power to relax is there, Your Lordship, where the council is satisfied in receipt of reference from the concerned state government.
Now you submitted that it's done by, it's not done by SDO.
Yes.
It's done by, yes, it's done by chairman of the SDO.
Chairman is sub-divisional
state
school.
government that special circumstances exist warranting relaxation of some of the provisions of the regulations.
Where are you reading from?
I'm reading at page 17 of the writ petition, Your Lordship.
It's a type of every day that is, it should be there.
Very difficult. The threshold also, she shouldn't have. Where are you reading from?
Rule 5 of power to relax.
There's a council.
Page 17. Yes, the NCT norms, Your Lordship. There is a power to relax.
No, this is different. This is different. This is a different constitution altogether. Suppose certain state, then you write with NCTE for infraction of this norm. Not this doesn't concern one teacher.
No, but
sorry.
Your Lordship, even page 13 of our affidavit also shows that, Your Lordship, being a contractual post and in remote area, Lordship, NCT norms can be relaxed.
Not remote area.
With reference to the subject cited above,
priority be given to
inform you that priority should be given to NCTE.
Then the NCTE,
qualified teachers and
NCTE,
all, but she's also not qualified. Her only claim to that post is because she's got.
Understand.
49.
If the other respondent doesn't cross the threshold itself, how is the application accepted?
Because there is a provision for relaxation, Your Lordship.
No, there's no provision for relaxation.
And all steps should be taken to ensure.
Appointment.
Then, Your Lordship, in fact, my first limb of argument is that this case is
arbitrary.
That this case is suffering from inordinate delay yet unexplained
No,
latches also,
doesn't
Your
mean
Lordship.
that when a cancellation that you'll get it. No, it will be re-advertised.
Lordship.
Yes, simple as that. Yes, heard Mr. P.T. Sangma with the petitioner.
And their own also claim is that
We'll give a chance to the
Lordship. I have no problem with
we'll
regards
give a chance.
to
You take notice this one because it's going to
She
affect
has
it
to,
adversely.
Yes, Lordship.
Yes,
I will participate.
In the course of the hearing, it appears that the appointment of the respondent number 9,
number 4, Your Lordship.
number 4 will not be able to withstand judicial scrutiny in view of the requirements which have been prescribed by the state respondents itself. In brief, the writ petitioner. No, don't write this. No, leave that. However, before that, he does not give the pre-finding yet. Huh?
Just find out what is the elementary.
Perhaps one of you will withstand judicial scrutiny. Yes. Stop.
How is she called? She did not.
Though it is stated and seen from the records that the respondent has been for, as any order that may be passed would affect it adversely, the petitioner is permitted to affect justice service, as also the school. Which school is this? Service. Yes, and the respondent number. Respondent number. No.
They are not.
Respondent number.
Chisu Bibra Government LP School.
No. The name of the SD. SD was respondent number
3.
Respondent number 3.
Yes, Your Lordship.
Is directed to inform the petitioner or the respondent number 4 personally about the existence about the matter. Then it become an advocate to ensure compliance of the order. You tell SEO to inform just after 2 weeks. As will go. So the basic threshold not meeting. Other considerations always there. That means.
Number 2.
Must be associated. Please, Lordship, this matter, the one of the respondent, they have not filed the miscase application. We have not received. Therefore, I am asking that I may be allowed to file the rejoinder to the PDP.
Yes, my lord. The status that was asked for me to check, my lord, is as per the order dated 15/4/2026, my lord. My lord. Order dated 7/5/2026 in Miss Case 123 of 2026. My lord, it has been disposed of. This is the application that I filed for impleading GHDC. The reason being, my lord, is because we made payments to GHDC to make payments to the Nokmas. Now, my lord, no liberty has been given to me to file fresh, my lord, because there were certain defects on my impleadment application. That is all I asked for, my lord.
Going to file afresh?
Yes, my lord. I filed fresh. I have to file this impleadment, my lord. That's all, my lord. At this stage, I'm only asking for. Of course, they can file a rejoinder.
No, we are not objecting to her filing. She has filed twice.
Yes, my lord.
But it was disposed on the ground of defect. There is a defective in his because he has not.
Where's the? You file a miscase for recall with order first on the defects.
Yes, my lord.
Do it and don't make it a defective application.
Yes, I'll do that.
Apply your mind, yes.
Yes, my lord.
Much less.
This is matter after 2 weeks of further orders.
Bless my lord.
Most obliged, my lord.
Item number 3.
May I please, your lordship.
Lordship, this matter has come back from mediation. Not yet.
No, your lordship.
Cannot be resolved.
Affidavits have been exchanged.
Your lordship will be filing praying for some time, your lordship.
Yes, this matter returned back from mediation on being unsuccessful. Stop. MS Ailingwa for
All the respondents, your lordship.
space 4 is allowed.
2 weeks time, your lordship. 4. Much obliged, lordship.
Lordship, here I'm seeking some more time to file my rejoinder. Fix for rejoinder.
When do you file affidavit?
This is
We have filed on the 15th of May, my lord.
More than 1 year, 1 month.
Lordship, this is the first second time.
Space 4 is allowed for the 2 weeks time to file rejoinder.
Lordship. Obliged.
5.
3, my lord. I have filed my affidavit.
May please, your lordship, I am for respondent number 4, 5 and 6. I've filed my application for calling order dated 06/5/2026, Your Lordship, which was passed by
Where's
this
that
honorable
person
court.
speaking from? Can't see him also.
Oh, I think my camera is not working, Your Lordship.
What's the matter about?
It's a NOCMA related matter, my lords. 4, 5 and 6 are the private respondents. Matter had proceeded ex parte against them. No, it's 4, 5 and 6 are the
filed
private
my
respondents.
application for calling this order, Your Lordship.
I'll listen after 1 week. You come personally.
Lordship.
This after 1 week due to technical.
My affidavit may be taken on record, my lord. I
Technical
already filed.
issues on the part of the respondents 4, 5 and 6. Counsel for respondent 4, 5 and 6. So Mr. SD submits that on behalf of respondents 1, 2 and 3. Affidavit since been filed. Yes.
Man, highly blessed.
6.
My lord, the respondent number 2 was supposed to file the affidavit, my lord, and they have not filed till
Who
date.
number 2?
My lord, the CHC, my lord.
What the?
CHC, Sora Community Hospital, my lord. Respondent number 2.
Where's MSS Bhattacharjee?
My lord, kindly have the last
But
order,
you
my
were,
lord.
but there was mentioned me that you are unwell and
Lord.
assurance were taken.
No, that's my apologies, my lord. Actually, I had gone to school, my lord.
There's no excuse. But then, why do you see you unwell? Did Mr. Sham say she's unwell? He's unwell.
So, probably she's mistaken, my lord. My apologies.
Oh, personal difficulty. Yes, you're appealing for.
Your Lordship, I'm appearing on behalf of Miss Edi Sharma for respondent 5 and 6. She's indisposed, Your Lordship.
No, what about
Your Lordship, I'll be filing my affidavit during the course of the day, Your Lordship.
My lord, kindly have the last order, my lord. This was the third occasion. Today is the fourth occasion that I was still asking for time, my lord.
You have to bear with it. You can't help it.
My
Yes.
lord, kindly appreciate, my lord, this is a
I'm
my lord,
ready,
urgent
I'm
matter,
ready,
my lord.
everything's fine. I
The
could not
petitioner
stop
has
the
lost her
copy
house, my lord, now. Kindly consider, my lord. She was living in a rented accommodation. Now she's lost her house, my lord. Kindly.
You file affidavit. Okay, you see the affidavit first. Yes, sir. Mr. H. Abraham submits that the affidavit behalf of respondent 1 to 4 will be filed in the course of the day. What about 5 and 6?
She has already filed, Lordship.
5 and 6 already filed. Other respondents affidavits already on record. Just after 1 week for rejoinder, if any.
Kindly, my lord, post for hearing, my lord.
No, you can just hold it up. In case you want to file rejoinder to the affidavit, how do you know? Yes, you can serve a copy.
I'll be serving. I could not serve.
Yes.
Highly blessed.
This matter has been sent back from the mediation, Lordship, and I have filed my counter, Lordship.
My lords, respondent number 4 is yet to file the
Accountant general.
filing,
Your Lordship, I've already sent for signatures.
Yes, MSU PASA for 4 submits affidavit will be filed within 1 week.
Lordship.
Yes. Just thereafter for rejoinder. 2 weeks after rejoinder of any years.
Obliged, my lord.
8.
My lord, this can be posted for final hearing, Lordship. I have 2 weeks. After 2 weeks, Lordship.
No rejoinder. Mr. S.A. Sheikh submits that rejoinder will be necessary. Accordingly, it's a matter for hearing after 2 weeks. Yes.
Apply.
Let's on.
9.
And please, Your lordship, we are already filed affidavits.
Yes.
I've already filed affidavit.
Today?
Yesterday. So we filed yesterday, Lordship. We have received a copy, Lordship. I'm
One?
referring for rejoinder, Lordship. Filing your rejoinder.
One, any affidavit? Yes, MS Sijala, 1.
Lordship, they're not filing.
They're not filing. Yes. Your name?
Laman.
Yes, Laman.
Laman,
sorry, yes. Yes, now submits that the affidavit behalf of 2 and 3 be filed in the course of the day. Was already filed.
Already filed.
Has been filed today itself.
Yesterday.
Okay, it's already been filed. Stop, Mr. Snaitang, praise once allowed.
2 weeks close.
To file affidavit. Yes, to file rejoinder.
Bless up.
10.
Please, Lordship. I'm filing this my affidavit in opposition during the course of the day. I prepare some the notice also.
We received it.
Yes,
Lordship, this matter can be disposed of, Your Lordship.
Now only.
I have just
Can be
filed.
disposed of.
Affidavit be on record.
Let the matter come up next week, Lordship.
What's the matter about?
It's a transfer petition. regarding matrimonial proceedings.
You objecting?
You're objecting, my lord.
I'm the wife in this.
You're the wife.
Yes, Your Lordship.
You want to transfer to Tura?
To Tura, Your Lordship.
Where is it pending now?
It's pending before the Learned Tribe Court here in Shillong.
Shillong.
Let affidavit be on record. Yes, sir. Mr. P. Sama submits that affidavit since been filed. List after 1 week.
Lordship.
Yes.
What place, Lordship?
11.
So, that's your thought, show me. That is file. Mr. Lasong Luria submits that no rejoinder will necessary.
Lordship.
List after 1 week for further order.
Lordship.
Further order stage even. Yes.
11.
Much place, Lordship.
Maybe Lordship.
Yes.
Item 11, my lord, kindly see last order, my lord. This is a covered case. The petitioner's ACR has not been taken into account for the period of ERA duty, my lord.
Yes.
Please, Your Lordship. Your Lordship, we want to file an affidavit, Lordship.
Why?
Just for the record, Lordship. We've received parawise yesterday, Lordship. Kindly grant us another 1 week's time, Lordship.
So you don't dispute it's not covered. It's covered case, correct?
Lordship.
Yes.
We want
My lord, this is a covered case, my lord.
Let them put on record an affidavit, yes. Though MS Emir Chang Vice, Dr. N. Mozika, that JCI has stated that he will be allowed to place an affidavit on record. Though, as we're going to stop, the same objected to by, though it has been submitted on the occasion by Mr. V. Kumar that the matter is covered, however, in interest of justice, how much time is required?
2 weeks, Lordship.
2 weeks time is allowed for the affidavit.
Highly obliged.
My lord, deep your lordship.
Yeah, I'm praying for some time for counter appeal.
How many times you prayed? How many times?
Twice. This had come up for more.
Twice.
Come up for more on 20th.
Yes, for the 2 weeks time has been allowed affidavit, yes.
13.
Deep your lordship.
Please, Lordship.
Please,
Lordship, I'm praying for 3 weeks' time, Lordship, to file my affidavit.
On behalf of whom?
Respondent number 1 to 3.
For file.
No, but I also seek some time.
You're out 3 weeks time. Last occasion. What's the matter about?
The election of the Panmusikam.
Election of the?
The reconstitution of the
Constitution of the state.
So you're the vital respondent.
These, my lords, but technically the state who has to conduct the elections, my lords. So we are waiting.
No instruction yet.
No instructions. Who's the officer concerned? We'll call him here.
The health department. Kindly allow 3 weeks, Lordship.
We'll give 2 weeks. Otherwise, if no instructions are received, the school assists you. Yes, MS Ladu for 1, 2, 3, and ICMD for 4. Break for the 2 weeks time. Affidavit, yes.
Much obliged.
14.
May please, Lordship. Your Lordship, I pray for 2 weeks, Your Lordship, to file the affidavit, Your Lordship.
Yeah, 4, 5, 2, you're for whom?
1, 2, 3. Respondent 1 to 3, Your Lordship.
4, 5, 6.
I'm for 4, 5, 6, Your Lordship.
You also will file affidavit?
Yes, Your Lordship.
Yes, Mr. Saman.
Yes, let
2
him
weeks
file.
per time as great lot of respondents for affidavits. This is the draft answer.
Much place, Lordship.
15.
May it please Your Lordship. Lordship, in this matter, we're supposed to file an affidavit bring on record. We've served them an advance copy, Lordship. We'll be filing in the course of the day.
This is 2, 3 tender matters.
My lords.
They were cancelled and
Yes,
refloated.
yes. There is some development that in all 3 tenders, in all 3 schedules, same bidder is L1, and this time in one of the bids, schedule 15, he is bid 29% below the reserve price.
Who, the respondent?
The L1, now the present L1. They've opened the cost bids.
He is not a party here.
He's not a party here. We weren't even aware. So now in the GEM portal it is indicated L1 in all 3, and internal news that he's going to be allotted. And in one of the bids, 29% below the reserve price. I'll file a rejoinder. Give me about 10 days time.
The matter will become.
I understand, but lordships are still seized with the matter just to examine the main issue.
If there's no point, if you're not going to serve any purpose, What should be the court's time examining whether actually right or wrong if a third party interest has been created?
Yes, my lord. No, it has not been created yet.
No, once L1's
Yes.
third party interest has been created.
No, my lord, he's L1 so far. I'm in one of them. I'm L3, in one of them I'm L4. So if it all it is already granted, then naturally this becomes infructuous. I'll withdraw it. In the meantime, I'll file a rejoinder, my lord.
Yes, Emily Chang submits that after it's since been filed.
We'll be filing in the course of the day.
Will be
Lordship.
filed in the course of the day. But however, an advance copy has already been served upon the Learned Counsel for the petitioner. Mr. S. Sanapuri, please submit that he is in receipt of a copy and please allowed
10 days.
10 days time to file a rejoinder.
Lordship.
Please
Obliged.
16 and 17, similar matter, Lordship.
15, 16 and 17.
He also will be filing affidavit in the course of the day, Lordship.
You have received copies of the all three. Same order, 15, 16, 17.
18.
My lord, I represent respondent number 2 and 3, my lord. My instruction, my lord.
Yes.
My lord, the senior electrical inspector has been assigned to conduct the inquiry, my lord. When the time the writ was filed, my lord, before that he was already being assigned to conduct an inquiry. So we are waiting the inquiry
Have
report,
you
my
paid
lord.
anything to the
My lord, once we are expecting the inquiry report by this weekend, my lord, or to the most first week, my lord, next week, my lord.
Well, if you want that by next week we'll post this matter again.
My lord,
Okay.
My lord, on the direction of court, the notice along with a copy of writ petition was served to respondent 4 and 5, but it returned back to registry.
my lord, I am just for information, my lord, my friend has made FEDCO a party here. In one of the matters, my lord, 3 matters are there. FEDCO is basically been assigned only the Garo Hills. So this matter pertaining to Jainte Hills, my lord. So I don't know why.
And who's
They're
the
not
who's-
necessary
who's the
party.
agency?
So I don't know why they have
Not
assigned.
necessary
You will
party.
strike them off.
Yes,
FEDCO has been
my
appointed
lord.
only in the Garo Hills, my lord.
I notice.
They are not working in. Yeah, they are not existing.
Left permanently. Oh, they had an office here. Yes. You are Mr. Upadhyay.
Lordship.
That's number 4 and 5.
Yes, my lord.
Yes, Mr. Upadhyay submits that the respondent number 4 and 5 have been wrongly arrayed as parties. Inasmuch as the area of operations only in Garo Hills.
They are.
This submission is concurred to by Ms. R. Kuni appearing for the respondents number
2 and 3.
2 and 3. Accordingly, respondents 4 and 5 shall be struck off from the array of parties. Now, what is your submission?
My lord, we are awaiting the inquiry report, my lord.
Yes, on the matter and issue, the Learned Counsel for 2 and 3 submitted that an inquiry has been instituted and the report is expected by this weekend itself.
My lord.
Yes, this is matter after 1 week
My lord,
for the orders.
next week I have difficulty, my lord.
Then someone else put there. We can't. A child's hands and legs.
Then my lord,
hands have
Friday,
been
my lord.
amputated.
I'm praying for Friday otherwise, my lord.
Yes.
I'll try on Friday, my lord.
Friday is 19th,
My lord,
26th.
it will be 26.
Yes.
Deeply obliged.
Those matter 26th.
Madam.
Otherwise, in intervening
Madam,
period
I am also
you
pursuing-
kindly ensure that they get some.
My lord, I'm pursuing with the
ex-gratia.
department concerned, my lord, with regard. I have gone
So
through
to
the
get
file,
some
my lord.
ex-gratia
Yes, madam.
payment.
Yes,
you have
madam.
a scheme
I've spoken to them regarding the gratia.
regarding
Something
is
can be
no
done.
no affliction of any fault.
My lord, I
A
have
child been electrocuted, arms have been amputated,
My lord,
both of them.
At my personal level, my lord, I'm pursuing with the department, my lord, with
Yes.
this case. My lord.
Deeply obliged.
Yes.
Hearing 26.
Yes. Yeah, Mr. Shah.
Yes, Your Lordship. Your Lordship, the conducting counsel for this matter is not well, Your Honor. So,
Who's he?
we're looking for another date, Your Lordship.
Who's he?
N.I. Chaudhary.
He informed you prior, no?
2 weeks' time, Kindly be given, Your Lordship.
Mr. Which is where's the thing? The issue. Yes. Mr. R.K. Shah, Learned Counsel for the Police Service Army Council. Mr. N. Chaudhary.
Yes, Your
Lordship. Dispose. Subjectly prays that the matter be taken after 2 weeks. Not objected to by MS C. Jala for the Vice Dr. M. Mozika for the respondents. Just after 2 weeks. Yes.
Highly obliged.